Great. Well, good morning.
Good morning.
So we're going to talk about a topic. Actually, we're going to cover two things. First is some very basic information about estate planning, especially for New Jersey residents. And then we're going to talk a little bit about plant giving to benefit the church, because Bishop Sally has asked congregations to please speak with their people about plant giving. I have a prayer to open with. This is my stewardship prayer. The Lord be with you.
And also with you.
Let us pray. Generous and loving God, we come to you with grateful hearts and eager minds, knowing that all we are and all we have come from you. We offer you thanks and praise for the beauty of the earth, for our families and friends, for all the blessings of this life, and even for the challenges you place before us. Help us make stewardship of your gifts our way of life, so that we may serve our congregations, our communities, and the world with the gifts you give us as faithful witness to Christ our Lord. Amen.
Amen.
So here are the basics. First of all, a lot of people don't think they have an estate. And I often hear that, especially from younger people. Well, I don't have an estate. I don't need an estate plan. But the truth is, you probably do have an estate, and you have probably sufficient property that it creates an inconvenience when you go as an executor to handle someone's estate. They might have a car you need to sell or to transfer title, or they might have a bank account nobody remembered, or a CD, or you might have an income tax refund that comes in the mail, and maybe an unused insurance premium. And in order to deal with those checks, you sometimes have to go to the surrogate's office. Frankly, you usually have to go to the surrogate's office in order to deposit or sell or transfer and get a certificate of your capacity as executor. So most of us have an estate. Do you need an estate plan? Yes, you do, because if you don't do the planning for yourself and for your family, the state of New Jersey has a plan for you, because the law has its own set of rules about who receives property from an estate where there is no will. So there are some essential documents for everyone's estate plan. The first is a will. Even if you have a very modest estate, you can have a very short will. And it's something that these days you can probably find a decent form online. However, if you have concerns about, let's say, a child who needs a little support, who isn't quite capable of managing their finances, and you want to have their money held in trust, I would not suggest using an online form. Or if your spouse is developing dementia and you want to make sure that the assets you own are being cared for and not distributed to your spouse outright, a trust is helpful so that someone can manage the surviving spouse's financial affairs. And so for that reason, I don't recommend that people use an online will form if there's some complexity in your estate. When people have done that in the past in my firm, we used to call that an annuity for lawyers, because they would invariably make a mistake, or there'd be some ambiguity in the document that they had created online.
What's it called?
Well, I would call it an ambiguity, where sometimes an online document has phrases that contradict each other because the person creating it from an online form didn't quite understand the words in the document. And so we would call that an annuity for the lawyers, because it was like the gift that kept on giving. You know, we would have to keep helping our client interpret the will. Sometimes a revocable trust is appropriate. You will hear revocable trusts being promoted all the time. in New Jersey, they don't accomplish much. You don't need a revocable trust, really, unless you have property outside New Jersey. Let's say you have a home in the Poconos and you don't want to go through Pennsylvania probate. A revocable trust will take that out of Pennsylvania probate. It'll be owned by the trust. It'll pass to the trust beneficiaries. A revocable trust is useful for that. Or let's say you inherited assets from your ancestors and you want to keep them segregated so that they pass to your descendants but not to your spouse. And you want to be able to identify them specifically. Sometimes a revocable trust is a good little bucket to hold those assets. You should have a durable power of attorney, which appoints someone to make financial transactions on your behalf when you can't for any reason. And you should have a healthcare directive, healthcare power of attorney. No matter how young you are, you should have that. Now the will, we say it speaks as of the date of death, and it can be revoked, it can be amended, changed, so long as you're competent. And what the will does is distribute your probate assets, assets you own in your individual name, to your beneficiaries according to the terms of the will. A revocable trust, if you go that route, created during your lifetime, holds assets for life. It can be funded during your lifetime. In fact, there's really no point in having it unless you want to fund it during your lifetime. It can be revoked or amended while you are living incompetent, and it distributes the trust assets to beneficiaries after your death. So will, trust, what should I have? Well, I mentioned already the times that a revocable trust is useful. Sometimes a revocable trust is really helpful for an older person who doesn't have someone they can appoint as power of attorney, doesn't have a trusted family member or friend, and a revocable trust with sort of a disinterested trustee, excuse me, like a bank, for example, can manage basic financial transactions for you, pay your mortgage, pay your bills, receive your dividends and income. Because it's really not unusual to find an older person who is maybe doesn't really have dementia, but they've reached a point in life where they're just not paying attention to things. And we've seen this, I've seen this with my parents. They don't open their mail. They're often getting dividend checks, and they don't open the mail and deposit it. And then you find on their death that there's a stack of mail that hasn't been looked at. They're not looking at their statements. It's because life is so complicated as it is as you get older. Just getting up in the morning and making sure you're taking care of yourself and taking care of your health, that some of these things are ignored. For that reason, a revocable trust can be helpful. But on the whole, they don't save taxes, they don't save time, they're more expensive. And so if you have financial advisors out there flogging revocable trusts, you don't really need it unless there's a special circumstance. And no matter what, you're going to still need a will. You're going to still need an executor to take care of your final affairs. There's very often, in most of the estates we see, property that didn't make it into the revocable trust. The executor is responsible for that. And so you will have to have a will. So one of the questions, is it probate and passes through the will, or is it non-probate? And a lot of people forget that in New Jersey, at least in this part of New Jersey, a good deal of our wealth is tied up in retirement plans. That's just not unusual for people. And a home, of course, and the home is often owned as joint tenants. Well, we call it tenants by entirety for real estate, but joint tenants with right of survivorship, and it's going to go to the surviving spouse if the surviving spouse is, still with us. And so that's a non-probate asset, but then people forget that if you own, say, the house at the shore with your siblings and you have a fractional interest in real estate, that's usually a probate asset that's going to pass under your will that you've got to plan for. And sometimes, and as I mentioned before, there's money payable to your estate after your death, like unused premiums or a tax refund. That's all probate property. Non-probate property, real estate you own jointly as tenants by entireties, which is what spouses do, or a bank account you own as joint tenants with right of survivorship, financial assets that are pay on death, retirement plans and life insurance with designated beneficiaries. Those are the typical non-probate assets. Powers of attorney, I think, are very important. If you travel, or if if you just need to have somebody available to handle things for you because you're not present in order to sign your name or conduct a transaction, whether or not you're incompetent, power of attorney is very useful. People in the military need a power of attorney. And I think the military always insists that you have a will and a power of attorney and a healthcare directive before you go overseas. But as my former partner used to say, you've broken both arms and you can't sign your name. The power of attorney is very helpful. But often the power of attorney allows someone to manage your finances for you in order to avoid the complexity and the expense of a guardianship. A formal guardianship is done through an application to the court. It requires affidavits from doctors. It requires financial records be submitted to the court, and every person who might be eligible to become guardian has to be notified and either has to raise their hand and say, yes, they'll do it, or the court will choose among them. And the court may decide nobody in the family is capable of being guardian, and therefore we're going to appoint a lawyer on the list that the court keeps. So in many instances, the power of attorney can take the place of a guardianship. And we call it durable because it survives disability. I think this is one of the most important documents you can have, a healthcare directive, sometimes called a living will, and a healthcare power of attorney, or medical power of attorney, or proxy directive. You know, New Jersey was at the forefront of the laws on substitute decision-making. And some of you will remember the Karen Ann Quinlan case. She was a young woman, and it's my understanding, I could be wrong, but she had been partying. And perhaps she overdosed, but she fell into a coma. She never recovered from that. And her parents wanted to remove life support. And there was no law in New Jersey at that time. And so the court had to make a decision about what would she have wanted if she had known that she would be in this situation. And so the parents had to substitute decision making. And then there's a whole line of cases that came down about the same time before the legislature passed laws that permit the creation of a living will and a power of attorney for healthcare. So the living will is typically just directions. It's like if I am ever in a state where two doctors have certified that I'm incapable of making decisions for myself, I want the following things done. And that's important and that's helpful. But the really important part of the document is the power of attorney, where you have named someone you trust and have talked to them about this to make healthcare decisions when you cannot make them yourself. And that means you are unconscious, or it means you have severe dementia, or you could be under anesthesia and the surgeon has to make a decision and needs to speak with someone before, say, amputating a foot. I just, these are the sorts of things that come up. So having someone you trust who will carry out the decision, even if other members of the family say, don't do it. And this often arises. You'll have siblings who will say, no, mom needs every ounce of care and medical attention that we can provide. And another child says, no, I talked to mom and she said to me, if I'm ever in this situation, please don't keep me alive unnecessarily. And so you can minimize conflict if you have someone you've designated to make these decisions and you trust them and you've had the long conversation about what you want done. These things always come up when it's unexpected. We always think mom or dad or whomever will be fine and they'll be out of the hospital and we'll be able to talk about it. And you know what? Life just doesn't roll that way. It just, things happen suddenly, unexpectedly, on their own timetable. When I have had healthcare power of attorney for people, I have carried it in my purse. And the reason for that is in our healthcare system, someone, let's say they're in a assisted living and they get a urinary tract infection. And in older people, that tends to cause like an episode of dementia. And so they're rushed off to the hospital. They're stabilized. So you go to the hospital, you tell the nurse, I'm the power of attorney, and you write your name on the whiteboard at the foot of the bed, and you put your phone number down. You show them the document. That your family member or whomever gets a little better and they send the person to rehab. Well, over at rehab, they don't know that you have power of attorney. So you have to go to the rehab place, show them the document, make sure the nurses know, put your name on the whiteboard. Well, the next thing you know, they're back in the hospital. Different floor, different set of nurses. You've got to keep this information with you. I have done this, and it's crazy, but I just kept it in my purse until my client died. And it's just how it is. That's our healthcare system. But those are the essentials. So I'm going to stop here and take some questions. Any questions?
I've heard there's some people who have advocates. What do they do? Are they any?
So I don't know what is meant by advocate in terms of what they do at Windrose. Someone with power of attorney can be your advocate. But if Windrose has a sort of informal kind of advocate system, I'm not familiar with that.
I think it's personal.
So you can always have a friend that you've talked about with this who can be sort of can help, be an advocate, can speak for you if for some reason you're not up to it yourself. But they have no legal standing. Yeah, unless they've got a document that appoints them as a power of attorney, whether it's financial power of attorney or healthcare power of attorney. Any other questions? Yes?
What are the implications of probate or non-probate? And you mentioned beneficiaries
Mm-hmm.
in terms of having one or not having one.
So the implications of probate and non-probate are how the assets will pass. So right now I'm administering an estate as a home. There's the contents of the home, some of which are valuable. There are bank accounts. She was a widow, and all of her beneficiaries are charities. She has a will that describes what she wants done, and the proceeds of sale of various assets will all go to charity. She also had an IRA. An IRA is a non-probate asset. It's not governed by her will. There's a specific beneficiary designated on that IRA. And as soon as the estate administration is complete, that beneficiary will receive the IRA. If she had had life insurance, which at 95, no one really needs to have life insurance, and she had a designated beneficiary, that would get paid almost immediately. It would go, the beneficiary would have to notify the insurance company. The executor would probably find in the records who the insurance carrier was and something to do with the beneficiaries. Most people keep those records. would notify the beneficiary, give the beneficiary a death certificate. The beneficiary would notify the insurance company, provide proof of who they are, and the insurance company will pay those things out almost immediately. Some people create pay on death accounts or transfer on death accounts as a sometimes called the poor man's will. So you create an account that is your own during your lifetime, but it says, pay on death to my nephew. And the bank may or may not release that right away because in New Jersey we have an inheritance tax. I didn't go into tax stuff here. I could very briefly. New Jersey does not have an estate tax. An estate tax is basically an excise tax on the value of your estate. The government takes a portion from the value of your estate. New Jersey does not have that. The federal government has an excise tax like that, an estate tax. The exemption this year from federal estate tax is $15 million per person, $30 million for a married couple. Most of the people I know don't have $30 million in assets. We have some clients who do, but most people I know don't. And it used to be much, much lower, which is why people think about the estate tax. It used to be an exemption of $600,000 and almost everybody paid some estate tax. That's not true anymore. And the exemption at $15 million will probably continue to rise a little bit every year as it has in the past decade. New Jersey does have an inheritance tax. An inheritance tax is a tax on the transfer between the deceased and the beneficiary. So certain transfers are exempt. You can give as much property as you want to your spouse, to your lineal ancestors and your lineal descendants without tax. So parents, grandparents, children, grandchildren, great-grandchildren. But if you make a gift to your sibling or a godchild or your neighbor, that gift may be subject to tax depending on the size of it. And the tax starts at 11%, and it can go up to 18%. And so even a very small gift may incur tax. So I don't tell people don't leave gifts to your nieces, nephews, godchild, best friend, siblings, whatever. But in your will, and this is another reason for having a will, specify how that tax will be paid. Because by law, the tax is paid by the recipient of the gift, unless the will provides that the tax is paid from the estate so that the recipient receives the full value of the gift. Now, with a monetary gift, it's not so hard to subtract the tax if the will is silent or if there is no will. It's not so hard to subtract the tax from the amount going to the beneficiary. But if it's real estate, where's the money going to come from? So if you own real estate and with a sibling and say you want to transfer your share to your sibling will receive your share, but they're going to have to come up with 15% perhaps of the value of that share in cash to pay the state, unless the will provides that the tax will be paid from the estate, and then the beneficiary receives the value of the real estate without tax. So I didn't put that into today's presentation, but those are things you should be aware of. Yes, Roland.
Suppose you want to leave all your assets to the charity.
That's free of tax.
And your children don't like it.
Well, I'll tell you, that happens. That happens. So children and others who anticipated being beneficiaries can bring a lawsuit You can't stop people from doing stupid things like bringing lawsuits that they may not win. But sometimes you'll see people do it in hopes that they'll get a settlement somehow and they'll get paid off. It's unfortunate. And then they'll be saying, well, you know, Dad was under the influence of Father George, who exercised undue influence over him. Some terrible thing like that, which, you know, but these things do happen. And especially when a will change is close to death and you see somebody in the final year of their life, if they're elderly or they're ill, suddenly gives all their money to charity. And then the family goes, wait a minute, that wasn't the way it was planned. We didn't expect that. And then you have a challenge, the potential for a challenge. These things do happen, but a well-drafted will, not made on your deathbed, with evidence that you had an interest in a particular charity during your lifetime, for example, you gave regularly, is generally sufficient to prove your gift to charity.
Do the witnesses to your signing of the will make a difference then in that case, that they can say you were competent?
Well, the witnesses are usually employees of the law firm that prepared your will, and they come in for a moment, they sit down and they sign. They don't necessarily know you. You shouldn't have family members as witnesses, I can tell you that. Don't put your beneficiaries or your executor or family members as witnesses if you can avoid it. If you can avoid it. Although during the pandemic, when we were signing wills on the hoods of cars outdoors and trying to grab any person we could to be a witness, sometimes we had to fall back on family members, but it's not a good practice. Yes, Michael.
I have a question. Is it legal to attach conditions to the use of the money?
Certain conditions. Some are against public policy. For example, I had a client who wanted to leave a large portion of his estate to his son if he would divorce his wife.
That's a good one.
That was against public policy, and we wouldn't let him do it. It wouldn't have been enforceable.
Well, the example that happened to me was when my great uncle died in California in the 1960s, and he gave money to me and to my brother for college educations with the condition that none of it would be used to study music, the fine arts, dance, drama. Now, that was not a problem for me because even though I was deeply interested in music, I'd already decided to go into engineering. So that was okay. For my brother, it was a problem, particularly when he was at Tisch School at New York University.
So sometimes these conditions are just ignored because you know there's only so much you can rule, like the dead hand, the rule from the grave, right? Sometimes an executor will go to court for an interpretation. A judge might have found, well, that's not appropriate. That's against public policy. We're not going to restrict someone's education. I mean, there are gifts to universities and others. There's a well-known one that went back years and years ago, I mean, decades ago, a gift to Rutgers, I believe, and to provide scholarships for young men who were not prone to drink, smoking cigarettes, or gambling. The donor's idea being that if you had the money to do those things, you didn't need a scholarship. So you can put some conditions on, you can put age conditions. For example, hold in trust until my son is 25, pay him 1/3 at that time, hold the balance in trust until he is 40, then pay him another third. You know, you can do things like that. That's very common.
Well, my brother resolved it by double majoring at NYU.
Well, there you go.
And business administration.
So
the money paid for the business administration.
So there are ways around these things. And I do tell people there are ways around some provisions in a will. Nothing is carved in stone.
Well, what if someone attaches a condition to money given to their children, saying they have to produce grandchildren in order to get
That would be against public policy. All right, let's talk about planned giving. So, planned giving is just what the name sounds like. We plan for a lot of things in life. We plan for purchasing a home, educating children, our retirement. Well, we can also plan to be charitable. And the benefit, and really the gift of a planned gift, is that it has a way of elevating the church or the other charity to the level of family. You're giving assets to family, you're giving assets to your congregation. They are sharing in the wealth that you have stewarded during a lifetime. It also can sustain your pledge. These planned gifts generally take effect at death, but not all. Some can provide a source of income during life, and some might offer tax savings. Now, planned giving, is this something that the church should even care about? Yes, of course, because people don't think that Jesus talked about money, but the fact is Jesus talked about money and possessions all the time. And he knew the power of money and possessions to warp people's behavior. So this, you see the barn there, and this little passage comes after the parable about the greedy farmer whose crops produced so well that he tore down his barns and built new barns, and then said to himself, "Soul, eat, drink, and be merry." And then a voice says to him, "You fool, tonight your life may be demanded of you, and then who will get your assets?" And so Jesus ended that parable with this: "Do not be afraid, little flock, for it is your Father's good pleasure to give you the kingdom. Sell your possessions and give alms. Make purses for yourselves that do not wear out, an unfailing treasure in heaven, where no thief comes near and no moth destroys. For where your treasure is, there your heart will be also." The church also has something to say about it. Now, Episcopalians on the whole don't like to talk about money. It's because it's not polite. We don't talk about money or politics. We don't want to do anything that might offend people, but the Presbyterians are very good about talking about money, and so are some other denominations. But for us, we do have this little passage which is hidden in the prayer book, and I think it's in the rite for welcoming a child, like an adopted child. If you pull out your prayer book and you look at page 445, you will find this. "The minister of the congregation is directed to instruct the people from time to time about the duty of Christian parents to make prudent provision for the well-being of their families, and of all persons to make wills while they are in health, arranging for the disposal of their temporal goods, not neglecting, if they are able, to leave bequests for religious and charitable uses." You can see how we hide this stuff. And I don't know why we aren't more open about talking about wealth, generosity, the effect of wealth on us, and honestly, the effect of being generous, how being generous just soothes the soul in ways that being acquisitive does not. So there are some basic planned gifts I wanted to cover. There are gifts that we say mature on death. Those would be a bequest and a will, or a payment from a revocable trust at death, payment from a life insurance policy, or a distribution from a retirement plan. And that actually is one of the easiest ways to make a gift, is to designate some fraction of your retirement assets for the church. Then there are gifts that benefit the donor and potentially others during the donor's life. And these are gifts where you transfer assets to either the charity or to someone else, and you get some income in return. Charitable gift annuities are annuities. They're contracts, but they are offered by charitable organizations. For the Episcopal Church, it's the Episcopal Church Foundation. So you transfer, I think it's a minimum of $5,000 to the organization in return for a contract. They agree to pay you a small amount. It's not as large as a commercial annuity, but that's because the idea is this is a charitable gift. We want to make sure something remains at the end. And then there are more complicated ones involving attorneys, charitable remainder trusts, great for receiving highly appreciated stock with very low cost basis. Charitable lead trusts pay a stream of income to the charity and then the balance of the trust after a period of years to members of the family typically. You can also give a remainder in real estate. This is a huge nuisance, but I've known people to do it. So you have a vacation home and you would like your church to have the home and sell it when you're done with it. And so you give by deed what's called the remainder interest, the future interest, to the church while you retain the use of the property. It's complicated, but people do it. People do it. So those are gifts that provide life income. And then I call these gifts that require some planning to do. So a gift of appreciated securities. Don't sell the stock and give the cash. Give the stock and let the charity or the church sell the stock because they won't incur capital gain. IRA rollover distributions are very good, and I'll show you an example of that. Sometimes gifts of art, a little complicated, but in the right circumstance, that's a good thing. But you could also give a car or a boat. And then you can also give other assets like real estate, although any potential recipient is going to have to do an environmental survey and a marketability survey, and they can say no to the gift because sometimes real estate can be, a contaminated corner lot in some downtown area, and nobody's going to want it, right? Paid up life insurance, if you still have those things, and a donor advised fund I added. And I'll talk about those later. I'm not a huge fan of donor advised funds. I talked to Matt at length about this the other day, and he's a fan of donor advised funds. I'm rather indifferent to them. But let's talk about the charitable IRA rollover distribution because these are easy to do for people who are the right age and have retirement assets and are receiving their minimum distribution amounts. So you have to be at least 70 and a half years old. Now, even though you don't have to begin taking from your retirement plan now until you're 74, this statute was passed back when it was 70 and a half. And so that hasn't changed. And it counts towards your required minimum distribution. So the total amount given cannot exceed $115,000 per year, and this is indexed for inflation. And your spouse can also do this. And then anything that exceeds the exclusion amount would count as your taxable income. But here's an illustration. So an 80-year-old has $1 million IRA and wants to give to the church and reduce taxable income because maybe they have income from other sources. So the donor asks the IRA custodian, you don't need a lawyer for this, you just ask the IRA custodian to transfer monies to the church. And here we have an illustration of $20,000. The required minimum distribution for this person was $49,504. $20,000 of that they want to go to the church. The donor receives the balance, $29,504. That becomes part of the donor's taxable income. That's a very easy way to make a gift out of a retirement plan during your lifetime. Here's an illustration of a charitable gift annuity, which I spoke about a moment ago. It's a contract. You don't need a lawyer. The Episcopal Church Foundation offers these. It provides a fixed income for one life or two lives. On the death of the annuitant, the person receiving the annuity, here I have Episcopal Church Foundation pays the residuum, what's left over, to an Episcopal charity of your choice, a church or a school. They have a minimum contribution of $5,000, and you have to be 55 years old. And there is some tax benefit. You get an income tax deduction in the year of the gift, and if you fund it with appreciated assets, you can minimize capital gain over time. So here's an illustration. A 70-year-old and a 65-year-old contribute $20,000 in cash to Episcopal Church Foundation for a joint and survivor annuity. The annuity payout at this rate, which is a rate set by the American Council on Gift Annuities, it's used by most charities, it depends on your age. So for this couple, it's 5.2%. And so they'll get $1,040. And they get a charitable income tax deduction, which in the first year, if they can use the whole thing, which is based on the value over time of the annuity. So here's the illustration. I think it's pretty simple to figure out that when these folks have died, the money goes to the church. How am I doing for time?
It's 9:47.
Okay.
Yes.
All right, we'll quickly go through this. So the bishop raised earlier this year at a clergy conference the benefit of endowing a pledge. And I haven't found anything in the Episcopal Church literature about this, but the Presbyterians are thinking about it. So let's say you pledge $2,500 a year and you hope to endow your pledge after death. How much can you give, or should you give? So for all saints to receive the equivalent of $2,500 for, say, 5 years, you need to leave a bequest of about $12,000. This I would call an expendable gift in the sense that it will run out over time. But to endow the pledge in perpetuity, if there's really no such thing as endowing in perpetuity, but for a very, very long time, you need to leave a bequest of $50,000. That is your annual gift times 20, according to the Presbyterians who have figured this out and are promoting it to their congregations. So the first time, the expendable gift, we would see that sometimes among clients. They say, I want to leave, $250,000 to my college to fund a chair in social studies. Well, that amount is too small. But the college might take it and say, we can fund this chair for this many years. And we would call that a folding chair, because it would run out of money unless someone else came along and continued to endow that chair. But if you were going to endow a professorship for a long period of time, you might have to leave $1 million to do that. So this is one way to endow a pledge. Now, of course, it depends a lot on the organization receiving the money and how well they manage it and invest it, right? Because this assumes that this pledge, this gift, generates a stream of income for the church because it's being properly managed. Now, that's it I just wanted to give you some words of encouragement. I called this an act of grace and a legacy of faith. And it comes from this little passage in 2 Corinthians. And I actually should have started a little earlier, because what Paul is doing is telling the Corinthians that the poor churches in Macedonia, those poor little churches, had managed to come up with money to send to the church in Jerusalem, I believe, which was struggling. They found a way to do an act of grace and to send money to a church, another church that was struggling. And so Paul wrote, now as you excel in everything, in faith, in speech, in knowledge, in utmost eagerness, and in our love for you, so we want you to excel also in this generous undertaking. I do not say this as a command, but I am testing the genuineness of your love against the earnestness of others. For you know the generous act of our Lord Jesus Christ, that though he was rich, yet for your sakes he became poor, so that by his poverty you might become rich. That's it. Thank you. And I have a little time to take questions. Anyone who wants to ask a question. I know not everybody can stay.
Do you take private appointments?
I do not.
You do not.
I gave up my law license last year.
Yeah.
I got tired of my partners calling me up and saying, don't spend any time on this, but could you check on that? No, I wasn't. I used to consult for the firm. And once we got to that point, I was like, no, I think I'm just going to give up my law license.
So do you have recommendations?
I can recommend lawyers. I don't mind sitting down and giving people ideas, but it won't be legal advice.
No, this is not
Yeah.
a question of legal
Yeah.
advice.
Yeah.
So you would do that?
I'd be willing to talk to people about, where they could look
We would love
for
to.
help. Okay, sure. Yes.
If I move out of state at some point in time, do I need to then rewrite my will? And that means
It sort of depends on where you move. If you move to Florida, for example, or you move to the Southwest or to California, you really need a revocable trust in those states because of the way their probate laws work and because they also have a very complicated probate process. In New Jersey, it's essentially unregulated. The executor submits the will with a death certificate, receives a certificate appointing the executor, and then nobody really needs to hear from you again. There are no inventories, no accountings, unless a beneficiary requires it or the executor just wants to do it.
Colorado, my daughter's in Colorado.
So you would want to ask. Yeah. You would definitely need a new power of attorney because they reference state law. Yeah. Yes, Michael.
So vis-a-vis Colorado versus New Jersey or New York, when my father died in Colorado, his attorney told me and my brother that we were very lucky that the properties were all in Colorado because it has a much more favorable legal environment for handling of wills. Basically, the law out there presumes that the deceased was of competent mind and that they should trust implicitly whatever the executor decided to do.
Well, yes and no. First of all, every lawyer is going to tell you that the probate rules in a different state are complicated and much more difficult than they are here, right? I mean, that's really not, Colorado may be very easy. I don't know. Every state assumes that the executor, there's a presumption that that the testator was of sound mind. That's the initial presumption, always. And it has to be challenged by a beneficiary or some disappointed person. So in New Jersey, it really is unregulated compared to Pennsylvania, where you have to file annual reports. And Pennsylvania also has an inheritance tax on spouses and others. In New York, you have just a very tedious probate process through the surrogates court there. And if you're in New York City, it's even worse just because you have staff in these offices who are overburdened and slow to respond. And here in New Jersey, it's so easy. Just if you're in Mercer County, just drive down to Trenton with the will and a death certificate and your checkbook. It takes about 20 minutes, costs a few $100s. The people in the office are very nice. The same is true in Middlesex and Somerset. In Somerset, the surrogate will come out and shake your hand because he wants you to vote for him the next time round. So it's a pretty unregulated, pretty simple process here.
I just want to add something to that. From when my mother-in-law died in New Jersey, it is very important that the executor, well, in this case, the executrix, have a power of attorney and also have joint access to the checking accounts.
That's not true.
No?
I will disabuse you of that notion. One of the problems we see in practice is people who put their name on their parents' account because they do it as a convenience. And it's not so bad if it's a small account, and it's a couple $1,000s and they're just helping to pay bills. But very often the account is $10,000, $20,000 or more. Now, mom dies, the presumption is that whole amount of money will belong to the child whose name was on the account. That's the presumption. And if that child is greedy, he'll keep it. But, the proper thing to do would be just say, look, this is here, I'm going to divide it among my siblings, or I'm going to put it into the estate. But you don't always see that behavior. It's not necessary to have a joint account for a convenience like that. A power of attorney taken to the bank so that the account reads, mom, and then POA, son's name, is the better way to go, because then everyone knows that when mom died, it was her money and it didn't belong to the person with power of attorney. People always worry, oh, there won't be enough money for the funeral. Oh, there won't be. All of us have credit cards today. And the funeral directors know how to deal with this. They get paid first, by the way. There's a statutory schedule for payment. And the funeral directors get paid first. So they know how to work this out. You put it on a credit card, and once the estate is open and you have a checking account in the name of the estate, and that might be a month later, then you pay the funeral director, you pay the final medical bills, you do whatever else is needed, pay debts. Yeah. So I don't agree with whoever said that.
Okay.
You had a question, Hey-Jin.
Thank you.
Sure.
Brother Megan, this is, very applicable to all of us individually. What does it mean for All Saints? What would be the best way for us to think about this with our assets, our estate in the future to bless our own community here?
So I would suggest that we follow through on what Bishop Sally French has recommended, that where possible, people consider providing a large enough gift to the church, whether from your retirement assets or from a savings account or investments, that would help to endow your pledge, if not in perpetuity, at least for some years to come. And I think that is what congregations are hoping people will do in terms of planned gifts. So I know that at All Saints we have, you want to speak to the investments? Scott, you just.
Yeah, so part of what we're trying to accomplish, we have a strategic plan. And in that strategic plan, this planned giving aspect is very important. So thank you very much for the just gift that you're giving us. And by the way, we are taping this so that others who could not be here can avail themselves of this wonderful knowledge and sharing this gift. That being said, in our strategic plan, it's not just about stewardship, which is so important to our congregation. It's also about planned giving. And then we're going to approach another angle. And Roma, you know this because I mentioned it to you. Looking at the possibility of grants and grants that would come in many different ways and shapes and forms. But I would encourage you to reflect on this, and we will post it. But also in your hands is a handout about planned giving here at All Saints. So we're really trying to start this up. And I certainly appreciate everyone's attendance, of course. And
You're most welcome. This is actually a topic that I love. I was for many years a member of the Gift Planning Council of New Jersey, and I have represented universities, independent schools, other nonprofits in the development office aspect, sort of advice to the development officers. Because, universities get weird gifts like a share of a syndicated racehorse. And they want to know, what do we do with that, right? Or they get gifts of Ethereum or other kinds of weird currencies. And what do we do with that? So I've always enjoyed this kind of work. It's very creative. It's very personal. But I think in the context of the church, the idea of letting things go and not being so bound up with possessions is really important. And as I said, Jesus knew just how much the things we own and the things we want have a way of corrupting us and our relationships with people, and certainly our relationship with God. So, but thank you all. You're welcome.
Thank you.